I'm attorney Mark Nicholson, also known as the Battery Man for my focus on battery cases, criminal battery cases. And I'm here today with, go ahead and say your name.
My name is Lola Milton. I am the executive assistant here at the firm.
And I'm Sarah Jackley, and I'm the intake specialist.
So we want to do this video today regarding young thug and what was going on with his attorney being put in contempt by the judge and saying, hey, you're going to have to go to jail for fighting for his client. I mean, that's what he was doing. He was basically saying, hey, judge, I heard that there was a witness that was in chambers with the prosecutor having ex parte communication with the court, which is prohibited. So what do you think about that?
I think a lot of people want to know what ex parte communication really is and what does that mean?
Basically, ex parte communication is having some kind of extra conversation outside of court with the court. So normally when attorneys speak to the court, they're supposed to be in court and it's on record and both parties are there. Ex parte is that they're having this conversation alone where one party's not there, and that means that you can't get in there and say anything because you're not there. You don't know what's going on. So the rules in all the states say ex parte communication is not allowed. Now, there are some situations where someone can have ex parte communication. I've had cases where you're able to file a motion for ex parte communication so you can ask for funds with expert or something like that that they don't need to know about. So basically, if you're trying to, as a defense attorney, go ahead and file a motion with the court to say that I want some money to get an expert. Well, the prosecutor doesn't need to know that. You can file a motion for an ex parte, so that way there's a record saying, hey, I want this to be ex parte so I can tell you kind of what I need so the prosecutor doesn't know. So there are instances where you can file for ex parte hearing. I don't know if that was filed in this case. It doesn't seem like it was based upon the reaction of the attorney. And it did seem kind of highly unusual that just asking a question about this hearing caused the judge to want to say, oh, I'm going to hold you in contempt. So basically think of ex parte meaning, some kind of communication where one party is not there. You're Xing out one of the parties when you're having this ex parte communication.
Right. I saw a great example about that too, stating that it's like a ref going into a locker room during the game, giving plays to the other team, and then when the other coach comes out and he's like, hey, ref, what was that about? And then instead of the ref explaining to it, he just kind of ejects him from the game and can't play anymore.
Yeah, that's a really good example. Where'd you hear that?
I think TikTok.
Oh.
Where I find all my great information.
Yeah, that's what people are doing now. The TikToks for dances and recipes and legal advice. No, don't get your legal advice on TikTok. Come to us. So another thing people may want to know is what is like someone being held in contempt. And there's various forms of contempt. Not various, there's a couple kind that are mainly civil contempt or criminal contempt. And then you also have indirect contempt, which can be civil or criminal, and you have direct contempt, which can be civil or criminal. And basically with criminal intent, obviously, that's more serious, and, you're afforded the regular rights that you would if you're charged with a crime, because they're saying you're in criminal contempt versus civil contempt. Now, if you're in indirect, what do you think indirect contempt means?
It's not happening on the record in the courtroom?
Yeah, basically exactly right. If it's indirect contempt, normally what that means is it's something that happened outside of the courtroom. So that's what you normally look at. It didn't happen right inside the courtroom. And then direct contempt would be
in the courtroom,
yeah,
on the record, or does it have to be on the record?
Well, normally it's going to be on the record. I mean, I guess if the judge said, hey, we're turning the record off, and then you started cussing the judge out, that could be contempt of court. When you think of something that's indirect, it could be something that happened outside of court where someone didn't follow the judge's order. So the judge issues an order for someone to do something, and then they don't follow it. And then it's like, okay, well, this can be indirect contempt because I ordered you to do something and you didn't do it. So that could be considered a form of indirect contempt.
Right, like just not showing up for your court date.
Yeah, so not showing up for a court date, the judge could hold you in. They'll say contempt. I'm going to hold you in contempt if you don't show up. But normally that kind of contempt there would be an indirect contempt. But a lot of times they don't really do that. What they do is they just issue a warrant for the person's arrest. This is what they end up doing, at least when I see it happen here in Indiana.
It was definitely dramatic in that courtroom, him taking the tie off and everybody like kind of stopping and yeah.
He also said that he wanted to, if he's going to spend this time in jail, that he wanted to spend it with his client, so they could work on the case. Yeah, so it seems like this is really a pit bull of an attorney. Now, the news came out earlier today that he actually is not going to jail. That they allowed him to bond out. Some attorneys, or I don't know if it was him, that went ahead and filed a motion with the Supreme Court. Yeah, the Georgia Supreme Court has ruled that Brian Steele, what a great name for an attorney, all the steel that he has, the attorney for rapper Young Thug in the YSL trial will no longer have to serve jail time after being granted bond. So he was granted bond, so that way he's able to stay out. I would not anticipate the court upholding this contempt. It just seems, from the news media, obviously I'm not there in the courtroom, so I don't know all of what's going on other than when I read the news. But I just find it hard to think that they're going to uphold this type of sanction on the attorney for, and I don't know, was the judge acting improper with having this ex parte communication?
Right, definitely. So with the 20 days he was sentenced to serve on weekends, is that article stating that that's been overturned now?
Well, not necessarily overturned, but he's able to have a bond. So basically, It's like until the Supreme Court hears this and decides whether he should be held in contempt or not, he's out on bond.
He won't have to serve those weekends?
Right. So kind of like if you, which we rarely get these in Indiana, but if you are, let's say, convicted of a crime and the judge sentences you to jail, you could ask for an appeal bond, and then the judge could grant, an appeal bond, so you don't have to go to jail until after, or prison until after your cases went to the Court of Appeals. And if they affirm your conviction, then you would have to start serving your time. But if they overrule it, then you never have to serve.
Okay, yeah. That's pretty interesting. So I know this is all basing off of RICO charges. Who is he? What are they?
Yeah, Racketeer Influence and Corrupt Organization Act, and this is something that is mainly used for the feds, kind of created to take down organized crime. But apparently in some states, at least in Georgia, they have a version of it. I think they charge Trump with some form of this RICO. And of course, they're, saying that Young Thug was running this kind of criminal empire, influencing people and intimidating folks and doing all this other kind of stuff. So that's how they end up, coming up with this RICO charge.
Yeah, it's pretty impressive. They have, I believe it was 28 of YSL's signed artists under that indictment. So
yeah, I think they're trying to say that the YSL kind of is basically meaning like a gang name, so like a gang. I think when I looked it up, it said young. What did it say? Young Slime, Young Stoner Life label. At YSL actually signalized a violent gang, Young Slime Life. So
definitely not Yves Saint Laurent.
Yeah. So you've been very quiet, about all this. So what's your thoughts about an attorney being held in contempt?
Well, actually, I wanted to know if you guys knew, because I think Attorney Steele argued that YSL actually stood for something else, but but it was something like good. He turned it into something good. Did you hear
my favorite was when he took Young Thug's name and said the thug is the truly humble under God.
Oh, that must be what it was.
And then another one of the witnesses went on stand and testified that it was truly humble under God, as well as the hate you give. And so
that must have been what it was.
Yeah, it's been fun.
But as far as an attorney being held in contempt, I mean, he's a zealous advocate for his client. I don't know. Especially if the ex parte communication was not supposed to be happening, to then, if Attorney Steele is saying, well, this isn't supposed to be happening, I can't believe this is happening, this isn't good for my client, the state is doing things it's not supposed to be doing.
Right.
Why and then to just like take that out on his attorney, I don't know. That's not a good look. I don't think.
Right. I had a case where talking about the language, it was dealing with somebody was accused of being in part of a gang and shooting somebody over kind of like a threat, making threats to the person's girlfriend, whatever. And there was a rap song, and the detective tried to take the lyrics of the rap song to say this means that he committed this murder, and I mentioned, like, have you ever heard of Johnny Cash? And he said he has, and I'm like, well, you ever heard of, I shot a man in Reno just to watch him die? Mm-hmm. He lied, and I think he lied anyway. He said, oh, I never heard of that part. I've never heard that song. But it's like, do you think that just because he wrote that means that he's going to go shoot a man in Reno or whatever? And there are times, I think, where the government will take a rap song, a name or something like that, and then try to bend it into something that they want it to be, and it may be something totally different than what it actually is. And this is where they can try to get a charge by saying, oh, well, this means this. And it's like, you don't know that. Well, I was told that, by other gang members or, someone, or I had a class or whatever they want to try to say to make it seem like they are experts in whatever this is. And sometimes I'm just going to say this to try to get a conviction,
Right.
Another example that they'll use, and is a little bit different from a gang, is like on a certain type of case, they'll say, well, this is common. It's common for this to happen. This is common for someone's story to be inconsistent. But then they'll turn around, and if the story is consistent, they'll say, well, I knew they were telling the truth because the story was consistent. So it's like, so whether they're consistent or they're not consistent, there's always going to be the story that the police are going to say is like, well, this is common. And I've had cases where there's no signs of any kind of physical injury, and they'll say, well, that's common, that, there's no signs of physical injury. But yet, if there are physical injuries, then they'll say, that's it. Mm-hmm. My response to that is, officer, you're not saying the fact there are no signs of injury means that there was injury, So.
Or they want to say it's common, but won't pull out every single statistic they have on the commonality of whether that's true or not.
Right, yeah, they very rarely, I mean, it's interesting, they'll say it because my training and experience, but they won't get in there and show any kind of like, well, where's the book, that gets in there, where's this that says that, and then, jurors oftentimes, they think, oh, this is officer, and he said he's done all these cases, so he must be telling the truth, but it's like, where's the documentation that actually says the studies, because this person here is not an expert, and you ask them if they've written any peer-reviewed studies and things like that, they haven't, so they just get in there and say whatever they can to try to get a conviction. And I'm not saying in the Young Thug case that's the situation, because I don't have enough, I'm not the attorney on the case, obviously not the prosecutor, but I'm just saying it's common tactics that I see in law enforcement try to get a conviction and do things like that. So
certainly just flipping the argument.
Exactly, just flipping the argument, flipping the script is like they like to call it. Mm-hmm. And another thing they'll do is they will sit back and wait for the in this situation, the defendant, the person accused, to say something or do something that they can twist in that person in their favor. You know what I'm saying? So, for example, is if you don't speak to them, then they'll try to get in there and say, even though they're not supposed to, but I've had them try to slip up, like, well, the prosecutor, well, did he talk to you? No, he didn't want to talk. Then, like, if we had his side of the story, they'll try to slip things in there like that to try to get in and say, oh, well, he's not talking. And then if you do get in there and talk and tell him what happened, like, well, he wouldn't admit to this, or he denied this, and they make it seem like that you're just lying. So it's almost, that's why I tell people, don't talk to the police, because no matter what you say, they're going to try to spin it to make it seem like you're guilty, even if you're not.
And the stuff you do say, they're going to use against you regardless.
Yeah, exactly.
So you have to have your attorney present, for sure.
Definitely have an attorney present if you're going to talk to them. But mainly, don't talk to them if they're going to try to charge you with a crime. Like, what are you going to tell them? Anything they're going to use is going to be trying to convict you with it. So, my advice, plead the Fifth Amendment. You know what I'm saying? You got 5 fingers, 10 fingers actually. Plead it twice if you have to.
What started it all was the defense witness wanting to plead the Fifth, and that's what they went and talked to the judge about.
Yeah, exactly, and then once again you have a situation where sometimes it seems like when a defense attorney is trying to fight for his client, everybody's against them because it's like, well, this person automatically is guilty, they think, because you're representing them, and then you must approve of their actions because you're representing them, and it may not be the case, and they're going to make it as hard as possible for you to sit up there and fight because they want a conviction. So they kind of tilt the scales in their favor to get a conviction. It's in my experience. I'm just saying, and all I can speak about is my experience and what I've seen and when I've tried cases and I've watched other people try cases and reading in the media, that can be very difficult to try a case in front of a jury when it's notorious and it's very a lot of media and there's a lot of
Right.
government spinning things and stuff.
I think it's, I don't know, interesting that they never use other genres against people. They only use rap lyrics against people.
Yes, I would call that, it's a travesty of justice is what it is. But it does seem like you're right. You don't really hear a lot of country, folk, rock. You don't hear a lot of cases like that. It's usually some kind of the rap music things that they use to try to say, oh, this is an indicator of this and all that. All right. Well, that's your Nicholson Nugget of the day. Until next time, be sure to like and subscribe. See you later.